Hi, Nick Dogue with North State Law. We safeguard your professional license so you can get back to business. Today, we're going to talk about if a general contractor gets a complaint from the North Carolina Licensing Board for General Contractors, what should he or she do? So, first thing that a licensed general contractor is going to receive if there's a complaint that's been filed against him or her, it's going to be a notice of the filing of a complaint. So what that is, it's basically a cover sheet from the board stating, hey, if you're the qualifier for the company, you're going to be listed there, and then the company as well, the company for which you're qualifying licensee for. Both of y'all are going to be listed there. If you're a sole proprietor, it's just going to be your individual name there as the licensee and your license number, and it's going to lay out like. Not in great detail what the process is, just kind of the nuts and bolts of like the early stages of it. So they're going to say a complaint has been filed against your license. Be a couple things in there regarding, in the short time you're going to receive either a copy of the complaint or a summary of charges. Most of the time, you're going to receive a summary of charges along with that cover sheet, basically. And within that summary charges is basically going to be an affidavit preferring charges against a licensee. And it's going to be signed by the director of complaints and investigations for the licensing board for general contractors. Currently, that's Susan Sullivan. She's been there since '94. As a matter of fact, so she signs those. That's notarized, so it's a true blue affidavit. And that ends up being essentially the summary of charges. Now, it's usually pretty thin in regards to allegations. It'll have typically the statute that supposedly has been violated by the licensee. It'll have the date. And then if let's just say it involves a residential address, whether that complaint was submitted by like a planning department, permitting department, or an actual customer, homeowner, then they'll have the address on there as well. Other than that, there's typically not a lot on there. There's always exceptions. I've seen some ones that have been, like 90, 120 pages, things like that before. That's not super common. With that affidavit, there can be the actual complaint attached to it. And with that affidavit, or there might be a complaint and a number of other documents attached to it, like pictures of the house, contract, kind of things like that. And remember, in this video, we're talking about people that are already licensed with the GC board. We're not talking about unlicensed stuff. We'll do that in a different video and break down that, what to do if you have one of those complaints. So the biggest thing initially for the licensee here is you got to figure out, I have an option to send the board a written statement. I got to do that within 15 days, though, when I receive this notice of the filing of a complaint from the board. Now, sometimes it's beneficial to go ahead and send a written statement over to them. We've done that many times before and had some success with it. I remember one off the top of my head where I spent a bunch of time going through a lot of stuff that my client actually had that it was not provided to us from the board. They provided us a little bit more information than normal, but most of the information that we were able to utilize in our written statement came from my client in this particular example. And as a result of that, we were able to use that information and show, hey, this has nothing to do with the actual construction. It has nothing to do with any sort of maybe breach of contract shenanigans or anything that's a violation of the administrative code or the general statute for the GC board. This is strictly a civil dispute between the complainant and the licensee. Like I said, we spent a ton of time on that one, utilized a lot of information that thankfully my client had access to, and we were able to get that dismissed. And so it's a benefit sometimes to be able to utilize that opportunity with the written statement. Other times you may want to just keep your mouth shut because there may be some information out there that you don't want to disseminate to a third party. You definitely don't want to do it in writing. And you're not required to. You don't have any sort of mandatory cooperation with the GC board in North Carolina. The written statement's completely voluntary, so you don't even have to provide anything to them. You don't have to speak with an investigator. You don't have to provide them any sort of supporting documents or anything along those lines. If you do decide to do that, though, just do it the right way, provide supporting documents, things of that nature, so it makes it clear, like, hey, nothing was done wrong here, and here's my proof. There's a larger possibility of getting it dismissed and nipped in the bud at that point versus just not saying anything. Like, so if you've got the goods, so to speak, and you can show you didn't do anything wrong, do it as soon as possible. If it's more of a gray area, or if you're still confused as to what the nature of the allegation is, it's probably best to do either one or two things. Keep your mouth shut, not say anything, don't put anything in writing, or ask for more time and say, okay, can I have another 30 days to get you a written statement? Most of the time, they're reasonable when it comes to that. They want to see your side of the story. And if it takes you a little bit more time to kind of figure out what exactly is going on, then just ask. All they can tell you is no, or maybe they only give you 15 more days. So you got 30 tops instead of getting 45. So those are some options that you have right out the gate when you get this notice of filing of a complaint if you're a licensed general contractor in North Carolina. So let's say that this progresses. You either send them a written statement or you decide not to. And what happens at that point? Okay, so that's going to go over to the investigator. The investigator is going to wrap up their investigation. They're going to do an investigative report. It's going to have a plethora of documentation in it because we're dealing with general contracting work, and there's always a bunch of documentation. So there's always going to be pictures. Typically going to be some sort of permits or lack thereof, or some sort of lengthy contracts, or all of the above. So the investigator is going to get all that stuff, create an investigative report, attach all that stuff to it, and send it over to a review committee for the Licensing Board of General Contractors. So the review committee does not meet every month, which is why in the past couple years, actually going back a good bit, it's always taken a long time for these cases to get wrapped up. I'm currently working on a couple that have got about 4 or 5 years on them. 3 years, 4 years, 5 years. That's typically been the time frame. They've been a little bit quicker in the last 12 months because they've got new staff in there and they seem to be doing a better job. But typically, because they have so many complaints, it's usually dragged out. I don't think it really helps that the review committee doesn't meet every month, because even if they meet every other month, that's 6 times a year, obviously. I'm a lawyer, but my math's still pretty decent. So it can be a bit of a lengthy process as well. So once it gets to the review committee, they need to make a decision. And it's similar to the criminal law process where, you get to a probable cause determination stage. Is there enough probable cause to believe that the allegation actually happened? If so, it'll go forward. If not, it gets dismissed and it gets booted. So let's just say the review committee looks at it and go, I don't think that this is legit as far as this complaint's concerned. We're going to just dismiss it. Perfect. You're done. You don't have to worry about anything. Everything's kosher. Now, if they come back and they say, well, we think enough probable cause exists here to believe something happened, we've looked at everything, then what they're going to do at that point is make you an offer, okay? And it could be an offer that you can refuse. They're not the Godfather. They can't make you an offer you can't refuse. You can refuse it if you don't want to, or if you don't want to take it. So they'll send you something over via a consent order, and it's going to lay out a lot of different things. I've talked about that in a couple other videos. I'm not going to rehash all that here. And at the end of it is going to be kind of the meat and potatoes of it, like kind of the offer section, where they may want you to do a couple courses. They want to have you fine or something like that. Sometimes they may want to do an active suspension. Got to kind of understand the difference between an active suspension and a state suspension. State suspension means your license isn't suspended. Okay. Active suspension means your license is suspended. You cannot work under that license. Okay. So you got to read that stuff really, really carefully. And if you don't like that option, you don't have to take it. You don't have to enter into a consent order. You have to consent to enter into a consent order. So what happens after that? So I don't want to take this consent order. They want to take my license for 6 months. You can always request a hearing, and what the GC board does, and a lot of other boards will do the same thing. Is all right. Well, we sent in this offer, they rejected it. We're going to go ahead and we're going to put that in the queue for our hearing calendars. Their queue right now is pretty long. Again, it's not their fault. They just have a lot of complaints and a lot of cases going around. So that could end up being 12 months, 2 years, 3 years sometimes. It just really depends. They have gotten quicker, like I mentioned earlier, but there's still a backlog there. So you get a notice of hearing when your case is set for hearing. The silly thing in this state when it comes to licensing is they're only required per statute, and that's under North Carolina General Statute 150B. That's the Administrative Procedures Act, from notifying somebody that they have a hearing at least 15 days prior to the hearing. So that gives you less than 3 weeks to prepare for a hearing to defend your license currently. Some boards are pretty good about giving you more than the minimum, which would be the 15 days, and they'll give you 3, 4, 5 weeks. GC board, to their credit, usually gives people about a month, somewhere around there, which I think is appropriate. I obviously would prefer something like 2 months, just because you want to be able to do proper what's called discovery. You want to be able to interview witnesses. You want to be able to properly investigate on your end and things like that if you haven't done so already. But it is what it is at this point. Until we get some changes in 150B, we got what we got. So say you get the notice of hearing. Their notice of hearing is a little bit different. The first time I saw it, I was kind of a little bit confused, to be honest with you, because it'll have, like, I'm just using this as an example, January 15th, 2025, and then February 21st, 2025, and then April or May or July or August. And it'll have like 4 or 5 different dates. And that can be confusing to some people, but you got to look at it this way. The first date's the one that matters, because that's the next date up. If you're not able to be heard on that date and you don't get it continued, then that's the date that you're going. Now, if you're not going to be able to go that day and you get a continuance on it, or they tell you, hey, we had a change of plans, we can't do it this first date, it's going to move to the second date, and so on and so forth. You always want to get everything in writing with them, with anybody, but especially some sort of government entity. And email, especially nowadays, easiest way to go. I've always found that GC board to be actually pretty reasonable, to be honest with you. Don't tell them I said that. But they have been pretty reasonable when it comes to continuances. They have been pretty reasonable to deal with when it comes to negotiating. There's always times where, they're reasonable, but they have their limit of what reasonableness is. So the biggest thing when it comes to being a licensee as a general contractor is, you want to make sure that you keep up with your dates. You want to make sure you keep up with your paperwork that you receive from the board. I've had clients, come to me and, we think it's one complaint, and then, oh yeah, I forgot, I've got these like 3 other ones sitting back here. I'm like, okay, we'll have to work something out to try to deal with those as well. But the biggest thing is keeping up with your paperwork, keeping up with dates. I think the other biggest thing that I've noticed throughout the years is people don't update the board with their most recent contact information. And not only is that an ethics violation in and of itself, but it creates a situation where if something, God forbid, does happen, they're not going to be informed properly. And it's not the board's fault, because they were going by information that was provided to them by the licensee. So that's another big thing. You got to keep your information up to date with the GC board. All right. I hope that answered a lot of questions for everybody. If it did not, though, please check out the blogs on my website, northstatelawfirm.com. Also, check out the other videos that I have on the YouTube channel. That is North State Law's YouTube channel. And if you still can't find what you're looking for in either one of those spots, then give my office a call or text 919-521-8810, and you can get a free 15-minute discovery call with a member of my staff. And keep building North Carolina. You guys have a great day. Bye-bye.